I'm happy to announce that in relation to cricket today and movement in relation to cricket administration, that the Court of Appeal just ruled that the order that was originally made by the single judge in Chambers to suspend the major parts of the Cricket Administration Act, that order was discharged, which means that the Cricket Administration Bill and Act is now fully enforced once again. It also means that the original board, which was there prior to the Cricket Administration Act, they were the ones that the court had ordered that in the interim can act as the Guyana Cricket Board. That order has now been set aside, so that situation no longer exists. The next step for us is that we are going to have the Demerara Cricket Board elections, and then shortly thereafter the Guyana Cricket Board elections. Just to give you some background about what happened, in 2014 the Cricket Administration Bill was passed by this Honourable House, the Guyana Parliament, with support of the APNU, and in some years later the bill and act was challenged by some interested parties, the original Cricket Board, to say that it was unconstitutional. That case, which was challenged in the High Court, was dismissed, and an appeal was made to the Court of Appeal. In an interlocutory proceeding to a single judge in Chambers before Justice Barnes, Don Gregory Barnes, even though the Guyana Cricket Administration Bill was passed with the support of the members of the APNU, they then turned around with the Attorney General, as he then was, Basil Williams, and George Norton, had consented with the attorney representing the original Guyana Cricket Board, Roysdale Ford, had consented to the suspension of the provisions of the Act. I'm happy to say that there's significant movement in relation to cricket administration in Guyana, and that the provisions which were originally set aside or suspended have now been restored.